We are recording.
Thank you. Welcome to the Appellate Court morning session, Thursday, March 4th. We have two appeals to hear this morning. One went over. I would ask that everyone participating in this hearing, which is BOUTILIER v. Commissioner, introduce themselves, starting with the judges, then counsel for the appellant, and then counsel for the appellee. I am Judge Alvord.
I am Judge Cradle.
I'm Judge Lavery.
Morning, Your Honors. I'm Robert O'Brien. I represent Mr. BOUTILIER.
Good morning, Your Honor. I'm Linda Curry-Zafiro, and I represent the Commissioner of Correction.
Thank you. Counsel, prior to this argument, you received procedural instructions. Of course, you have also been joining us many times during this remote hearing. Do you have any questions?
No, Your Honor.
Okay. I am just reminding everybody that starting this week, all of our arguments are live streamed via YouTube. The Chief Justice has decided that this should include all cases, including those involving protected information. Consequently, I do request that if there's protected information as part of your argument, that you decline to orally state that, and that way we can comply with all applicable laws, and we will do the same as judges. Okay, and of course, please mute your mic when you're not speaking. So I think we're ready to go. Attorney O'Brien, would you like to reserve some rebuttal time?
As it happens, I would like to reserve 5 minutes, please, Your Honor.
My iPhone agrees with you. Okay. So I've reserved that time, and you can begin.
Thank you, Your Honor. Good morning, and may it please the court. Again, my name is Robert O'Brien. I represent Matthew BOUTILIER, and this court must reverse the habeas court because petitioner proved that he received the ineffective assistance of counsel at his second criminal trial. Obviously, there were two criminal trials here. Mr. BOUTILIER's habeas focuses on the second, which deals with the manslaughter conviction. And the only question with this shooting was whether it was justifiable or not. This is not a whodunit case. To put it simply, petitioner testified once before as to his self-defense claim, and the jury didn't convict him of anything with regards to the homicide case. Trial counsel advised him not to testify again in this trial, and he ended up convicted of manslaughter and sentenced to 40 years in prison. It's Mr. BOUTILIER's argument in the habeas, and I think he proved it to the habeas court, that no jury reasonably could have understood what they needed to understand to find that this was, in fact, self-defense. It came down to Mr. BOUTILIER. Mr. BOUTILIER testified as to his understanding, or he did once and could have again testified as to his understanding of his situation, his awareness of the danger to him, his fear of that danger, and his sense of what he felt that he needed to do. It's only once he put those things into evidence before a jury that a jury actually could have appropriately weighed that and considered that under the self-defense instruction. The justification for calling him for not calling him in the second trial, on the record of this case, just simply doesn't hold water. And that's for the fact of the matter that trial counsel's major justification for not calling Mr. BOUTILIER to testify in the homicide trial. Yes, Your Honor.
Yeah, but counsel, isn't that his choice?
It is his choice, but he can still be wrong. Oh, I'm sorry.
Well, but also, wasn't the habeas court's findings that the self-defense claim, as well as the consequences of him testifying versus not testifying, were thoroughly discussed with your client? I mean, that was from that was the court's findings from the petitioner's testimony, correct?
Yes, it is. Yes. And how is Attorney Pattis then and or Attorney Smith ineffective then? It simply was the wrong trial strategy without any reasonable basis for giving that trial strategy. And it comes back to, I mean, I feel like I've done this in the last a couple of appeals that I've had, really, but it's a unique case in that you have almost a perfected record of what could have been. And then you have a trial where it just didn't happen. Mr. Boutilier did testify, and the jury was not able to find beyond a reasonable doubt in that case where he did testify that he was guilty of anything. So it's not so much that it's not that we're taking issue, excuse me, with a lack of advice or just not thinking of it. I mean, Attorney Pattis is obviously an extremely experienced attorney who's done this. I mean, God knows how many times. He knew what advice to give, and he gave that advice.
In the first trial, he wasn't allowed to ask for manslaughter or lesser included charge. In the second trial, the state included the lesser included charges. So in the first trial, the attorneys for your client got him to a hung jury on murder. And in the second trial, they got the lesser included charge. How is that incompetence?
I think it's still, I mean, I think what it still encompasses, Your Honor, is that although it is the same strategy, I mean, he's still faced with murder in the first case and with the second case. Now, in the second case, it's essentially the same case as far as the homicide itself, although, you know, the evidence of the other shooting came in the second case as well, and that victim did also testify. So, you know, in one regard, it is different factually, in a lot of other ways, it's really not a different trial the second time around. The difference is, yes, as you said, we have a lesser included instruction, and does that change the strategy entirely? I mean, this isn't. I would say no, Your Honor, because this isn't as though the defense all of a sudden became an extreme emotional disturbance. If you successfully prove that, then yes, you're by law you're going for a manslaughter conviction. It's a self-defense case. It's still a self-defense case. It's still an absolute defense to any criminal liability. So it's still the same self-defense case that you have to put forward. I mean, there's I don't know if you want to call it a safety net or what. It's kind of close to that, in that there is a lesser included instruction that's now there, and it's now available and has to be taken into consideration. I believe it was, but it doesn't change the fact that it's still self-defense to murder.
Yeah, but you're saying, since the judge found, as a matter of fact, that he advised them of what he thought and told him he had a choice, but he would recommend not testifying, that's incompetence? It's
the recommendation that we get to, and it's the trial strategy that informs the recommendation that I'm taking issue with. And it all comes back to whether or not it is a reasonable trial strategy, given not only the charges that are against you, the main murder charge, the lesser included charge, but also the affirmative defense that's been put forward that the defense put on or took on an obligation to prove. So I think still, yes, at that point, it's still within the scope of it's still incumbent upon a reasonable attorney to give that advice and to formulate that strategy to prove up your claim.
But since he had a choice and he was given the advice, none of the advice as far as what he had a right to, and he was told what the attorney thought, and he was told it was his choice. So yes. Once he made his choice, even though it was the recommendation of the attorney, how is the attorney incompetent?
I guess it all really does come down to the specific advice, and not the general advice, as to the right, as to the availability to testify, and obviously the accurate advice that it is your choice. At the end of the day, I can't tell you you are or you're not going to testify. Nobody has that right. Only you, as a defendant, have the right to decide whether or not you're going to do it. So moving past that, because I make no claim as the propriety of any of that advice or the fulfillment of any of that duty. The claim then comes to the strategic advice, which it still has to be a reasonable strategy within the bounds of the law of self-defense. It's got to be essentially, I guess if you put it this way, you're putting forward the legal claim. You have to have the facts to back it up. And I don't think, especially on this record, especially on what Mr. Boutilier already testified to and what he already gave to at least one jury, with or without a lesser included offense, it's still self-defense to murder primarily. The fact of the matter still is there that he's the person who can say what he thought. He's the only person who can say what he perceived. He's the only person who can tell a jury why he thought he had to do what he had to do. Otherwise, it's it's a chart, it's a diagram of the kitchen. Otherwise, it's other witnesses, including one that the defendant shot, who you're supposed to get. I don't know. You're supposed to get helpful information out of that person at all. And then, at least in the second trial, this kind of touches on another claim that I brought up in the petition, but still, I think it still all comes back to, whether or not Mr. Boutilier had to be told of the importance of actually testifying and telling this jury what he thought and what happened to him. But now you have in the second trial, you have a jailhouse informant who is, not in the first trial, puts things together in the second trial and undermines the very notion of self-defense. Worst of all, perhaps, with words out of Mr. Boutilier's own mouth, supposedly, according to the informant, saying, he was laughing about it. He did it on purpose. He was going to try and make it look like self-defense. I think when you factor all, oh yes.
What did the counsel do wrong? He cross-examined him thoroughly. He brought out all the reasons why he's testifying. He brought out his entire record. He brought out that he's hoping to get himself a break from his sentence. I mean, what did counsel do wrong?
Well, specifically with that witness, instead of just moving past the testimony part, Your Honor, the advising of testimony. Yeah. With Mr. Bosk, there were at least a couple of major inconsistencies that were not brought out to the jury. And now, I think it's kind of a similar situation when you talk about the cross-examination of Mr. Bosk, as it is with advising regarding testimony. You've got foundation, you've got obvious planning, you've got preparation, and you've got proper advice up to a point, and then it's gone. There's no advice at the end to Mr. Boutilier that needs to testify and tell this jury what happened. With Mr. Bosk, there's exactly as you said. He has a lengthy record, a bad conviction.
It was all brought out.
It was all brought out. All of that was absolutely in front of the jury. But the fact that he said that he knew him before he couldn't possibly known him didn't come out. The fact that there's news reports circulating around a jail, there's at least a credible basis for where it is Mr. Bosk is getting any of this information that he could give to the jury. That doesn't come out. There are these things that I think what trial counsel did is a general impeachment. Thank you, Your Honor. It's a general reasons why is not to believe this person is a convicted felon. He's hoping to get something. And then beyond that, there's actual tangible inconsistencies, actual lies that he's putting forward about how he could know people and when. And that doesn't come out to the jury. So I think you have a case of almost getting there and then just not crossing the finish line. And it's incumbent upon a lawyer to cross the finish line when you're putting together these kinds of defenses and these kinds of avenues of attack as to the state's evidence. So I think that's what happened. That's what went wrong with Mr. Bosk. It's just very similar to what went wrong with Mr. Boutilier's advice as to his testimony. I saw that I only have 2 minutes. I imagine I only probably have about a minute left or so. As for the Joya claim, I would rest on my brief unless there are any specific questions about that, and reserve the balance of my time for rebuttal, Your Honors.
I have no further questions.
Thank you, Your Honor.
Judge Alvord, you were on mute.
Okay, thank you, Attorney O'Brien, Attorney Curry.
Good morning, may it please the court. Linda Curry Zafiro on behalf of the commissioner. All 3 grounds of the petitioner's claims are without merit and should be rejected by this court. I know we spent a considerable amount of time discussing the fact that counsel had advised petitioner that in fact it was his choice, and the habeas court noted that. However, a trial counsel's advice that the petitioner not testify at his retrial was objectively reasonable, and that's the standard. Had he testified, the state would have impeached his credibility. At the time of the shootings, he was unable to lawfully possess a gun. He had a felony conviction for criminal possession of a firearm. Attorney Pattis, in fact, testified that he didn't want to expose the petitioner to cross-examination regarding details of shooting the other woman, Ms. Aponte, multiple times, because on retrial, the petitioner was only charged regarding the Ramos shooting, so he didn't want to go over and go over those facts. And counsel did introduce other evidence showing the small size of the kitchen, which I think was the purpose of why the petitioner had wanted to testify, was as far as self-defense, and to explain that. They introduced photos and other evidence regarding the diminutive size of the kitchen, which was why allegedly the petitioner feared Ms. Ramos could push him down the stairs. And even if Attorney Pattis's advice not to testify was deficient, the petitioner failed to show he was thereby prejudiced. He failed to show that his testimony regarding his perceived need to defend himself from Ramos, who was, I think she was 125 pounds, considerably smaller than the petitioner and unarmed, that this would have been more helpful than harmful in light of the likely damaging cross-examination that he'd have been subjected to by Attorney Pattis. He merely speculates that because he testified at his first trial, the second jury could have found it different, and his speculation is obviously founded on improper conjecture. As far as the other ground that we've discussed, the matter of Mr. Fernando Bosk, counsel's cross-examination of Mr. Bosk was also objectively reasonable. An attorney's line of questioning a witness is tactical in nature. And as the habeas court noted, Attorney Pattis effectively impeached Mr. Bosk's credibility. He elicited testimony regarding his lengthy criminal record and the fact that he did have a motive to testify against the petitioner, which was to curry favor with the state. So on the totality evidence before the habeas court properly found that the petitioner failed to prove prejudice on this ground as well. It's not reasonably probable that the result of the trial would have been different had Attorney Pattis simply asked different questions. And I know we hadn't discussed the matter of Mr. Hoya, and I know petitioner has rested on his brief. If there aren't any questions to the commissioner regarding that ground of alleged ineffectiveness, the state will likewise rest on its brief.
I see no questions from my fellow panel members, Attorney Curry-Zafiro, so I think we're fine with your appellee argument. At this point, Attorney O'Brien, you do have your 5 minutes rebuttal time.
Thank you, Your Honor. I only have one very brief point, and it refers to whether Attorney Pattis's advice or his testimony about Mr. Boutilier being impeached if he were to testify as to the self-defense claim. That he wasn't allowed to possess a weapon, and he could have, of course, been confronted with the issue regarding with the shooting of Ms. Aponte. I think, in fact, Attorney Pattis's phrase might have been he didn't want to rekindle the flame or reignite the flame, something along those lines. Here's the thing, and this is where I had started talking about it in my first argument about the reason just not holding water. Ms. Aponte testified. She testified that she saw Ms. Ramos get shot. She testified that she ran away down a hallway. She testified that Mr. Boutilier went after her. She testified that she got shot twice in a hallway after running away from Mr. Boutilier. I don't know how much worse it gets. I don't know what impeachment could actually undermine him. So if that's the theory of why Mr. Boutilier shouldn't take the stand, it simply doesn't hold water. It was already all in evidence. If the jury gets confronted with it again, it's extremely unlikely that it would have forgotten that kind of fact. She was the very first witness that testified in the second trial. It doesn't undermine the fact that he still needed to put his case out there and his impressions out there. And unless there are any other questions, Your Honor, that was the only point I had to make on rebuttal. I would ask this court to reverse the habeas court's judgment.
Thank you to both counsel and the panel members. We will take this under consideration. We will now leave the hearing room.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.